Evicting a tenant can seem like a complicated process, but in this video, we'll quickly explain eviction laws in Florida and how to recover your property in 4 simple steps. First, what is an eviction? Eviction is the process of legally removing a tenant. It's illegal for a landlord to change locks or physically remove a tenant themselves. So, if the renter refuses to leave after violating their lease, you must seek an eviction from the court. The process for simply terminating a lease differs from that of an eviction. Lease terminations require proper notice from the landlord or tenant, and state conditions can be found on our website. Legal reasons for eviction in Florida. A landlord only has grounds to evict a tenant for reasons allowable in the state. The first step in the eviction process is to give the lessee one of the following notices. Non-payment of rent. If the tenant is late on rent, you can serve them a 3-day notice to pay or quit. This gives them 3 days to pay rent in full, along with any penalties, or vacate the property. Non-compliance. If the tenant violates their lease, a non-compliance notice gives the tenant 7 days to either comply with the lease or vacate the property. If the same violation occurs within a 12-month period, the tenant may not have an option to remedy the violation. There are other situations where a breach would be incurable, such as illegal acts. In these instances, the tenant must vacate within 7 days without an option to cure. Rent grace period. In Florida, there is no rent grace period. Rent is due on the due date. An eviction notice can be served if the rent is only 1 day late. 4 steps to legally evicting a tenant in Florida. Serve the notice to quit. Choose the form you need and download or fill it out on eForms.com. Post it on the tenant's door and also send it via certified mail with a return receipt requested via USPS. If the breach is curable, you must wait the specified number of days to give the tenant a chance to fix the problem. File eviction papers with the court. If the tenant doesn't fix the breach and remains on the property, the following documents should be filed in the court in the county in which the property is located. Complaint for eviction and damages. This complaint is used when the landlord seeks to obtain damages such as back, rent, cleaning costs, repair costs, etc., in addition to having the tenant evicted. Complaint for eviction re-breach. This complaint is for use when the landlord is seeking to evict for a breach other than non-payment of rent and not seeking damages. Complaint for eviction. The landlord may use this form when seeking to have a tenant evicted for non-payment of rent, but not seeking damages. The landlord will also have to file a summons with the complaint, summons for damages complaint, or summons for eviction only complaint. Await a judgment. If the tenant responds to the summons, a hearing will be scheduled. If they do not respond to the summons or complaint, you can request a judgment from the court. The following documents will need to be filed. For an eviction only, motion for default final judgment. For eviction and damages, motion for default with damages final judgment with damages. For both, writ of possession. If the tenant attends the hearing, but the judge finds in your favor, the tenant will be ordered to vacate. Sheriff's assistance. If the tenant is ordered to vacate and still remains on the property, you can apply for a writ of possession, which will allow the sheriff's department to remove the tenant and their possessions. Now you can get eviction proceedings started. Get eviction forms, court documents, and all other information you'll need at the link below for free.